Be ready. 5 seconds. Start. In regard to the juvenility of the writ applicant requires consideration. The same should be by the Sessions Court, that is the court which had originally tried the writ applicant for the alleged offence. In such circumstances referred to above, the learned counsel appearing for the state prays that let the Sessions Court look into the certificate issued by the medical board, including the family register, more particularly its authenticity and genuineness. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the only question that falls for our consideration is that whether we should ask the Sessions Court to examine the authenticity and genuineness of the documents sought to be relied upon of being a juvenile on the date of the commission of the alleged offence in the year 1982, and also subject the convict to further ossification test. The first and the foremost issue that arises for our consideration in this writ petition is in regard to the applicability of the provisions of the Juvenile Justice, Care and Protection of Children Act 2000. In the aforesaid context, we must first look into the relevant dates as 1. The date of the incident is 10th of September 1982. Thus, on the date of incident even, the Juvenile Justice Act 1986 was not in force. What was in force was the Children Act 1960. The Children Act 1960 was a beneficial legislation enacted to take care of the delinquent and neglected children. Under the said act, a child meant a person who had not attained the age of 16 years in the case of a boy and 18 years in the case of a girl. 2. The petitioner herein came to be convicted by the trial court by the judgment and order dated 6th of January 1986. Even on the date of conviction, the Juvenile Justice Act 1986 was not in force. The Juvenile Justice Act 1986 came in force with effect from 1st of December 1986. Thus, even on the date of conviction, the Children Act 1960 governed the field. 3. The appeal filed by the petitioner herein in the High Court of Allahabad against the judgment and order of conviction passed by the trial court came to be decided and was ordered to be dismissed by the judgment and order. It is relevant to note that on the date when the appeal came to be dismissed by the High Court, the 2000 Act was in force, and 4. A special leave to appeal filed by the petitioner herein in this court came to be dismissed by the order dated 16th of August 2016 as per the decision of the Juvenile Court. Stop.